Persons and family relations. Marriage. 1. A special contract of permanent union. 2. Between a man and a woman. 3. Entered into in accordance with law. 4. For the establishment of conjugal and family life. 5. It is the foundation of the family and an inviolable social institution. 6. Its nature, consequences, and incidents are governed by law and not subject to stipulation. What are the exceptions? Marriage is settlement, as it may fix the property relations during the marriage within the limits provided by this code. Article 1 of the Family Code. Marriage is an institution, the maintenance of which the public is deeply interested. It is a relation for life, and parties cannot terminate it at any shorter period by virtue of any contract they make. The reciprocal rights arising from this relation, so long as it continues, are such as the law determines from time to time, and none other, from the case of Goitia versus Campos Rueda, 1916. What are the requisites of marriage? There are essential and formal requisites of marriage. Under Article 2 of the Family Code, the essential requisites are: 1. Legal capacity of the contracting parties, who must be male and female, and 2. Consent of the contracting parties, freely given in the presence of a solemnizing officer. What are the formal requisites? Under Article 3 of the Family Code, the formal requisites are: 1. Authority of the solemnizing officer, subject to Article 35, subsection 2 of the Family Code. 2. A valid marriage license, subject to exceptions. And 3. Marriage ceremony. What are the effect of absence or defect or irregularity of the requirements of marriage? Article 4 of the Family Code. If an essential requisite is absent, marriage is void. If an essential requisite is defective or irregular, it is voidable. If a formal requisite is absent, the marriage is void. If the formal requisite is defective or irregular, there is no effect, but it makes the party responsible for such irregularity civilly, criminally, or administratively liable. Note that the term defect is used for essential requisites, while irregularity is used for formal requisites. Essential formal requisites. Number 1. Gender. The best source for citing the requirement of male or female is still statutory, as provided explicitly in the Family Code. Article 1 of the Family Code. Marriage is a special contract of permanent union between a man and a woman. Sex is determined at birth. Marriage between two people who had the same sex at birth is invalid, even if one changes sex by law. From the case of Republic versus Kagandahan, 2008. Changing of sex in one's birth certificate on the basis of sex reassignment shall be denied, otherwise it would result in confusion and would allow marriage between persons with the same sex, which is in defense of the law, as marriage is a union between a man and a woman. From the case of Silvery versus Republic, 2007. But when the change in sex happens naturally, as when a person has congenital adrenal hyperplasia, CHA, or biologically or naturally intersex, the determining factor in their gender classification would be that they, having reached the age of majority, with good reason, thinks is their sex. Change in name and sex as registered is here allowed, from the case of Republic versus Gagandahan, 2008. Second essential requisite is age. Legal capacity. Article 5 of the Family Code states that any male and female of the age of 18 years or upwards, not under any of the impediments mentioned in Articles 37 and 38, may contract marriage. What are other impediments referenced? For legal capacity. Under Article 37 of the Family Code, it enlists incestuous marriages. 1. Between ascendants and descendants of any degree. And 2. between brothers and sisters, whether full or half-blood. Under Article 58 of the Family Code are marriages which are void for public policy. 1. Between collateral blood relatives, whether legitimate or illegitimate, up to the 4th civil decree. 2. Between step-parents and step-children. 3. Between parents-in-law and children-in-law. 4. Between the adopting parent and the adopted child. 5. Between the surviving spouse of the adopting parent and the adopted child. 6. Between the surviving spouse of the adopted child and the adopter. 7. Between an adopted child and an illegitimate child of the adopter. Between an adopted child and a legitimate child of the adopter. 8. Between adopted children of the same adopter. And 9. Between parties where one, with the intention to marry the other, killed the other person's spouse, or his or her own spouse. Limited emancipation. Parental consent. Parental consent is needed for parties between 18 to 21 years old, given by their father, mother, surviving parent or guardian, or persons having legal charge of them in the order mentioned in Article 14 of the Family Code. No parental consent is obtained. If no parental consent is obtained, it makes the marriage voidable under Article 45 of the Family Code. Parental advice. How is parental advice different from parental consent? Parental advice is needed for parties 21 to 25 years old. However, in the absence of such, does not make the marriage void or voidable. Absence will merely delay the issuance of the marriage license by 3 months under Article 15 of the Family Code. Third essential requisite is consent freely given. Consent here refers to the consent of the contracting parties. The consent must refer to the contracting parties' bona fide intention to be married to the other, that is, to make the woman his wife. People v. Santiago, 1927. In People v. Santiago, it was held that the marriage entered into by a person whose real intent is to avoid prosecution for rape is void for total lack of consent. Here, it was the intent of the accused, not the victim of rape, whom he married under duress, that was considered. The accused did not intend to make the victim his wife. He merely used such marriage to escape criminal liability. Absence of consent renders the marriage void, while defective consent makes it voidable. Article 4 of the Family Code. Situation. What if either party was of unsound mind? Under Article 45, Paragraph 2 of the Family Code. Consent was vitiated or defected. That makes the status of the marriage voidable. What if mistake was to the identity of the other party? That is, or for example, if one mistakenly marries the fiancé's twin. Consent is absent, therefore the status of the marriage is void. What if mistake is as to the legal consequence and nature of the marriage ceremony? Example, thinking the ceremony is a joke, pretend, or play acting, which means that the consent is absent, making the status of the marriage void. What if consent was obtained by fraud? For example, 1. Non-disclosure of previous conviction of crime of moral turpitude. 2. Concealment of pregnancy by another man. 3. Concealment of STD. 4. Concealment of drug addiction, habitual alcoholism, homosexuality, or lesbianism. Under Article 46 of the Family Code, the consent is vitiated or defective, therefore the status of marriage is voidable. What if consent was obtained by 1. Force, 2. Intimidation, 3. Undue influence? Under Article 45, Paragraph 4 of the Family Code, consent is vitiated or defective, the status of the marriage is voidable. What if marriage is entered into by a person whose real intent is to avoid prosecution for rape? consent is absent and therefore the marriage is void. Defects in consent are discussed further in voidable or annulable marriages. No substitute marriage. A judicial decree terminating the previous marriage is required for remarriage. Okay, let's go to the formal requisites of marriage. First formal requisite is marriage ceremony. No prescribed form or religious rite for the solemnization of marriage is required. Article 6 of the Family Code. A couple's written agreement where they declare themselves as husband and wife, signed by them before a judge and two capable witnesses, even though it was independently made by them, still counts as a valid ceremony. From the case of Martinez versus Tan, 1909. What are the minimum requirements prescribed by law under the formal requisite of marriage ceremony? 1. Appearance of the contracting parties personally before the solemnizing officer. Article 3 of the Family Code. 2. Personal declaration that they take each other husband and wife. Article 3 of the Family Code. 3. Presence of at least 2 witnesses of legal age. 4. Declaration shall be contained in a marriage certificate. Article 6 of the Family Code. And 5. Marriage certificate shall be signed by the contracting parties and their witnesses and attested by the solemnizing officer. Take note, in a marriage in article mortis, when one or both spouses are unable to sign the marriage certificate, it shall be sufficient for one of the parties to write the name of the said party, which shall be attested by the solemnizing officer. Under paragraph 2, article 6 of the Family Code. Place where marriage shall be publicly solemnized. 1. Chambers of judge or in open court. 2. Church, chapel, or temple. 3. Office of the Consul General, Consul or Vice Consul. Article 8 of the Family Code. What are the exceptions to public solemnization requirement? 1. Marriages performed in articulo mortis or in remote places under Article 29 of the Family Code. And 2. Where both parties requested in writing that marriage be solemnized at the place designated by them. Note, non-compliance with this requirement does not invalidate marriage. For example, more witnesses, meaning more people can notify the officer of the impediments of marriage. So, not necessarily nga, ang imong witnesses shall be limited to witnesses of legal age. Second, formal requisites. Formal requisite of marriage is authority of solemnizing officer. So, who may solemnize? Under normal circumstances, pwede na 1. Incumbent member of the judiciary within his jurisdiction from Article 7 of the Family Code. 2. Priest, rabbi, imam, or minister of any of the church or religious sect who must be 1. Duly authorized by his church or religious sect. 2. Registered by the Civil Registrar General. 3. Acting within the limits of the written authority granted by him by his church or religious sect. And 4. At least one of the contracting parties belong to the solemnizing officer's church or religious sect under Article 7 of the Family Code. And third of the normal circumstances as to who can solemnize is the municipal or city mayors under sections 4444 to 4445 of the Local Government Code. In Articulo Mortis, who can solemnize? In addition to those mentioned above, na-mention na ang katong tulo, if in Articulo Mortis marriage, in addition to the 3 nga mentioned, it can also be that 1. Ship captain or airplane chief may solemnize a marriage in Articulo Mortis between passengers or crew members, Article 7 and 31 of the Family Code. And 2. Military commander in a unit may solemnize marriage in Articulo Mortis between persons within the zone of operation in the absence of a chaplain, Articles 7 and 32 of the Family Code. Marriages done abroad, kinsay pwede mag-solemnize? It shall be 1. Consul General. 2. Consul or Vice Consul may solemnize marriages between Filipino citizens abroad. Only between Filipino citizens. General rule. Those solemnized by any persons not legally authorized to perform marriages are void, except when such marriages were contracted with either or both parties believing in good faith that the solemnizing officer had the legal authority to do so. Article 35, subsection 2 of the Family Code. Good faith refers to the questions of fact, not ignorance of law. Example, that they did not know the priest's license expired or thinking that the senator could solemnize their marriage. Note: an irregularity in a formal requisite will not affect the validity of the marriage, but those responsible may be held criminally, civilly, and administratively liable. Articles 4 and 7 of the Family Code. Marriage license. Third formal requisite is marriage license. Generally, the license required is that which is issued by the local civil registrar of the city or municipality where either contracting party habitually resides. Article 9 of the Family Code. Take note: no marriage license shall be issued by the local civil registrar unless the applicants present a certificate of compliance issued for free by the local family planning office, certifying that they had duly received adequate instructions and information on responsible parenthood, family planning, breastfeeding, and infant nutrition. From RA 10354, Section 15. Determination of age. How does the local civil registrar determine the age? Generally, the local civil registrar shall require presentation of original birth certificates or baptismal certificates, except when the parents appear personally or when the local civil registrar is convinced that the parties are of the required age. Where is the marriage license valid? It is valid in any part of the Philippines. What is the period of validity of a marriage license? It will be valid for 120 days from date of issue, automatically cancelled at the expiration of such period. Marriages celebrated without a marriage license before the effectivity of the Family Code are void ab initio, as marriage license was an essential requisite in the Civil Code. Co versus Republic, 2016. A marriage license which preceded the issuance of the marriage license is void, and the subsequent issuance of such license cannot render valid the marriage, except in cases provided by law. It is the marriage license that gives the solemnizing officer the authority to solemnize a marriage. From the case of Aranes versus Oxiano, 2002. Special situations. If the party had been previously married, she shall furnish, instead of the birth or baptismal certificate, A1. Death certificate of the deceased spouse. If cannot be obtained, the parties shall make an affidavit setting forth this circumstance, his or her status, civil status, and name and date of death of the deceased spouse. 2. Judicial decree of absolute divorce. 3. Judicial decree of annulment. Or 4. Declaration of nullity of previous marriage. Under Article 13 of the Family Code. Foreign nationals. What is the rule for foreign nationals when contracting marriages? 1. When either or both parties are foreign nationals, certificate of legal capacity to contract marriage is issued by a diplomatic or consular official shall be submitted before a marriage license may be obtained. Article 21 of the Family Code. 2. Stateless persons or refugees from other countries shall present an affidavit stating circumstances showing capacity to contract marriage instead of the certificate of legal capacity, under Article 21 of the Family Code. Take note: the Apostille Convention, which took effect in the Philippines on May 14, 2019, simplifies the authentication of foreign documents. Public documents executed in apostille contracting countries, once apostillized, no longer need authentication from the Philippine Embassy or Consulate General. In the same way, The Philippine documents apostolized by the DFA need not be authenticated by foreign embassies or consulate generals if the country is a member of the convention, as per DFA Public Advisory. Exceptions to marriage license requirement. 1. Marriage in Articulum Mortis, Article 27 of the Family Code. The marriage may be solemnized without the necessity of a marriage license. It remains valid even if a ailing party survives. 1. Between passengers or crew members of a ship or airplane. 2. Between persons within a military zone. And 3. Other situations in Articulum Mortis. Second exception to the marriage license requirement is marriage in remote and inaccessible place, Article 28 of the Family Code. Third exception to marriage license, marriages by Muslims and ethnic cultural minorities provided they are solemnized in accordance with their customs, rites, or practices. And fourth exception, marriage by parties who have cohabitated for at least 5 years without any legal impediment to marry each other, from the case of Linyal versus Badayog, 2000. Take note, a false affidavit of having lived together for 5 years as husband and wife cannot be considered as a mere irregularity in the formal requisite of marriage, but a complete absence, rendering the marriage void ab initio, from the case of De Castro versus Asidao De Castro, 2008. What are the requisites for the 5-year cohabitation to be valid for the exemption from acquiring a marriage license? 1. The man and woman must have been living together, husband and wife, for at least 5 years before marriage. 2. The parties must have no legal impediment to marry each other. 3. The fact of absence of legal impediment between the parties must be present at the time of marriage. 4. The parties must execute an affidavit stating that they have lived together for at least 5 years and are without legal impediment to marry each other. And 5. The solemnizing officer must execute a sworn statement that he had ascertained the qualifications of the parties and that he had found no legal impediment to their marriage, from the case of Borja Manzano versus Judge Sanchez, Admin Matters, 2001. Fourth formal requisite is marriage certificate. Is it a formal requisite? Where parties declare that they take each other as husband and wife, it contains the following. 1. The full name, sex, age of the party. 2. Residence, religion, habitual residence. 3. Date and precise time of celebration of marriage. 4. That marriage license was properly issued, except in marriages of exceptional character. 5. That parental consent was secured when required. 6. That the requirement of parental advice was complied with when required. And 7. That parties have entered into marriage settlements, if any, under Article 22 of the Family Code. Take note, not an essential or formal requisite ang marriage certificate, without which the marriage will be void. It is the best evidence that marriage does exist, though. Tenebro versus CA, 2004. Non-existence of a marriage contract will not overthrow the presumption of a valid marriage where the requisites for its validity have been complied with. Case of People versus Borromeo, 1984. Marriages celebrated abroad. General rule. Marriages solemnized abroad in accordance with the laws in force in that country shall be valid in the Philippines. Paragraph 1, Section 26 of the Family Code. Except when 1. Marriage where one or both of the spouses are below 18 years of age. Article 35, subsection 1 of the Family Code. 2. Bigamous or polygamous marriages. Article 35, section 4 of the Family Code. 3. Mistake in identity. 4. Marriages under Article 53. 5. Psychological incapacity. 6. Incestuous marriages. And 7. Marriage void for reasons of public policy, under Article 38 of the Family Code. Take note, this means that foreign marriage may still be recognized as valid in the Philippines, even if it would have fallen under Article 35 subsections 2 and 3 of the Family Code so long as it is valid under the law of the country in which it was solemnized. Okay, ang say kalainan sa essential requisites and formal requisites. Essential requisites is inherent in the parties and carried everywhere. Formal requisites are requirements independent of the parties. Essential requisites is based on lex nationali, or the laws relating to family rights and duties, or to the status, condition, and legal capacity of persons, are binding upon Filipino citizens even though living abroad. Article 51. Nationality Rule. Okay. Ang essential requisites. Formal requisites is governed by lex loci celebrationes. If valid where celebrated, then valid everywhere. Forms of contracting marriage are to be regulated by the law where it is celebrated. Article 2 of the Civil Code. Ang essential requisite, the foreign marriages void under Philippine law due to lack of an essential requisite, even if valid under the foreign law, will not be recognized in the Philippines, pero it can be recognized abroad. As to formal requisites, foreign marriages may be void in the Philippines due to the absence of a formal requisite under foreign laws. For foreign marriages may be void under Philippine law due to absence of pwede po ma-void. Okay. What is the proof of a foreign marriage in order that it may be upheld? 1. Provisions of the foreign law, and 2. Celebration of the marriage in accordance with the said provision. Foreign divorce. If the foreign spouse obtains a valid divorce decree abroad capacitating him or her to remarry, the Filipino spouse shall have the capacity to remarry under the Philippine law. Article 26, subsection 2 of the Family Code. The citizenship of the spouses at the time of the divorce determines their capacity to obtain a valid marriage. So kung Pinoy ka when you married, but you are of a different citizenship when you obtained a divorce, then the divorce is valid. From the case of Kita versus Dandan, 1998. A marriage between two Filipinos cannot be dissolved even by a divorce obtained abroad because of the Articles 15 and 17 of the Civil Code. Garcia versus Resho, 2001. Question. Since it is the citizenship at the time of divorce that determines the capacity to obtain a valid divorce, can spouses who are both dual citizens, Filipino and alien, get divorced? What if both spouses were originally Filipino or later naturalized, that is, lost their Filipino citizenship, and even later regained Filipino citizenship and are now dual citizens? So, what's the answer? Aliens may obtain divorces abroad, which may be recognized in the Philippines, provided they are valid according to their national law. The marriage ties, when thus severed as to one party, ceases to bind the other. From the case of Van Dorn versus Romilio, 1985. A divorce obtained abroad by a couple who are both aliens may be recognized in the Philippines, provided it is consistent with their respective national laws. Garcia versus Resho, 2001. Take note. Divorces obtained abroad by Filipino citizens may now be validly recognized in the Philippines, but only in cases of mixed marriages involving a Filipino and a foreigner. Matter da yapon. The case of Republic versus Manalo, 2018. In mixed marriages involving a Filipino and a foreigner, Article 26 of the Family Code allows the former to contract a subsequent marriage in case the divorce is 1. Validly obtained abroad by the alien spouse, and 2. is of the type that legally dissolves the marriage and capacitating him or her to remarry. From the case of Garcia versus Resho. Take note. Following the ruling of the Republic of the Philippines versus Manalo, the divorce may now be one that was validly obtained by the Filipino spouse against the foreign spouse. This is because Article 26, subsection 2 of the Family Code makes no distinction as to who obtains a divorce. All that is required is that it is validly obtained abroad. A Filipino who initiates the divorce proceeding against the foreign spouse still ends up with the same position as one whose foreign spouse initiated proceedings. They both no longer have spouses. There should be no distinction between the two cases in order to avoid the absurd situation where a Filipino spouse is still married to the alien spouse, even though the latter is already capacitated by his own laws to remarry and is no longer married to the Filipino. Courts will only determine 1. Whether the foreign judgment is inconsistent with the overriding public policy of the Philippines, and 2. Whether an alleging party is able to prove an extrinsic ground to repel the foreign judgment, that is, want of jurisdiction, want of notice to the party, collusion, fraud, or clear mistake of law or fact. If there is neither inconsistency with public policy nor adequate proof to repel the judgment, the Philippine courts should, by default, recognize the foreign judgment as part of the Committee of Nations. From the case of Fujiki v. Marinay, 2013.